Good morning, good afternoon, everyone. Thank you for tuning in to our intellectual property rights webinar. My name is Shelby Kintlachi. I'm the Export Business Development Specialist at the Arizona MBD Export Center, operated by the National Center. The National Center has gone global and is bringing new resources for exporting to you daily. Today, we'll be doing our webinar. The Export Center provides one-on-one counseling, trade market analysis, finance resources, and market guides for our new clients. Please contact me after the webinar if you would like to discuss more. Without further ado, please allow me to welcome our speakers for the day. Today, we will discuss, We will discuss different types of intellectual property and the importance of IP when exporting. Please put any questions for the speakers into the questions box and we will answer them at the most convenient time. Our first presenter is Susan Anthony. Susan Anthony is a Tribal Affairs Liaison of the Office of Policy and International Affairs with the U.S. Patent and Trademark Office, protecting intellectual property rights and exporting. She's also attorney advisor in the USPTO's Office of Policy and International Affairs. This is her contact information. Following Susan's presentation will be Richard Cole. Richard Cole is Deputy Director of the International Patent Legal Administration, and his contact information is here. He will be presenting Pursuing Patent Protection Abroad, including the Patent Corporation Treaty and the Hague System for Industrial Designs. Without further ado, everyone, please welcome Susan Anthony, and she will be presenting first.
So I have a considerable challenge because the most interesting part of Tuesday Trade Talks is in fact the talking part where all of you do the talking and Richard and I are put on the spot to answer. So although I have been given 20 minutes, I'm going to try to limit myself to 15, but I'm not going to cheat anybody. If you are anxious to have a copy of my slides, Shelby has both sets of slides for me and for Richard, and she'll be glad to send them to you after the presentation. But for now, it's Trade Talk Tuesdays, so let's just talk. So there are 4 types of intellectual property in the United States, and this is typically what we find in the countries around the world: patents, trademarks, copyrights, and trade secrets. There are some variations on a theme, but basically around the world, we'll find all 4 of these in any one country. So what do they protect? A patent may protect an invention, or a design, or a plant, asexually reproduced plant. Patents are government grants. Trademarks protect indications of source for goods or services. I'm feeling really rather hungry right now, and I really could go with a Hostess Ding Dong or a Hostess Snowball. I kind of crave my sweets at the moment. Third, copyright, which protects literary and artistic expression. And last, trade secrets, confidential business information. Now, when you look at this list, you probably use patents. You may or may not be developing inventions or have an ornamental design on a functional product that could qualify for design patent protection, or plants, but you may. Trademarks, everybody has a trademark. Copyrights, you probably have more copyright information, copyrightable expression than you have of anything else. And trade secrets, you may think you do not have trade secrets, but as a business, I assure you, you have plenty of them. So what are we going to talk about today? We're going to talk about a little bit about protecting intellectual property nationally, and then we're going to strip off our cap and talk about protecting intellectual property internationally. So there are some basic intellectual property principles that you need to keep in mind. The first, that intellectual property is territorial. What does that mean? It means that patents and trademarks need to be protected on a country-by-country basis. What about copyrights? Well, they too are protected under the national laws of a country, but there are 1 or more multinational copyright treaties that simplify protection of copyright across the world. You do not need to seek registration typically, but some countries do have registration systems. And trade secrets also are protected on a country-by-country basis, but there the means of protecting trade secrets can vary quite widely. And last, and unfortunately, intellectual property protection and enforcement varies by country. There is no one size fits all. So I spoke a little bit about patents. I'm going to defer to Richard to do far more talking about patents. But as I said, patent protection requires a government grant. Nationally, an application is filed with the granting agency, the U.S. Patent and Trademark Office. Internationally, an application may be filed directly into another country, or it may go through the USPTO into the Patent Cooperation Treaty for inventions, or through the Hague system for designs. I cannot stress the last bullet on this slide enough, but Richard will emphasize it considerably more. Obtaining patent protection is time sensitive, and although the United States has a grace period for filing, many other countries do not. Now, trademarks are just where I spend most of my time. In the United States, and this is why we have to remember that we have to take off our U.S. hat and put on our international hat when we're talking about trademarks. In the United States, trademark rights are based upon use of the mark in connection with goods or services. So many of us do not think about registration. Obviously, if you have a commercially valuable mark that has a shelf life of a year or more, you would certainly want to consider registration, but many people are not even aware that registration is a possibility. It's not required, as I said, but it does provide significant advantages. But registration is required in almost all other countries of the world to ensure adequate trademark protection, and that often comes as a surprise, a rather unwelcome surprise to businesses. And internationally, just like in patents, we have some filing treaties, multinational filing treaties. We also have a multinational filing treaty for trademarks. The United States is a member of the Madrid Protocol. So you could either file your trademark application for protection in another country directly into that country, or if you have several countries that are members of Madrid, you may find it easier to use the Madrid Protocol. The Madrid system would enable you to use one application, pay one set of fees, and then you could apply for protection in up to 126 countries. So of course, that is not all the countries of the world, but that is many of the countries of the world. And information about Madrid is available both on the USPTO site and at the World Intellectual Property site, and that information will be in your slides. I also want to mention the USPTO Native American Tribal Insignia database. That is not a trademark registration system, but it's a very important system of which I think many tribes are not aware. It is a database in which federally and state recognized tribes may record their official tribal insignia with the USPTO at no cost. Why do so? Because it allows the USPTO to consider the tribal insignia during the examination of trademark applications. And if there appears to be a false suggestion of connection between the mark proposed in the application and the tribal insignia of participating tribes, the examiner may refuse the application. Now, this is a national database only. This is not replicated in any other country of the world, but I thought it was important for you to know. And it's also important for you to know about the United States Indian Arts and Crafts Act. The IACA is a truth in advertising law that prohibits the use of the word Indian or tribal names to sell contemporary and traditional arts and crafts. But that, again, is also just a United States act and is not something that you would find in other countries. Copyright protection in the United States and internationally is a little bit different, I said, because it's you have automatic protection upon creation of the work in a tangible mode of expression. What did I just say? Once you write something down or paint it or sculpt it, you have copyright protection. Registration is not required in the United States. In fact, it's not required in any other country in the world that has a registration system. But registration does provide significant advantages here in the United States, and it also may provide advantages in those countries that have registration systems. not the least of which is putting others on notice of your claim of right and having that all-important certificate of copyright validity for enforcement authorities. And then finally, I mentioned that trade secret protection could vary quite widely across the various countries of the world. Trade secret protection protects confidential business information that is kept secret. How do you keep it secret? Different countries have different rules about that. In the United States, we say that trade secrets must be protected through reasonable efforts. And what is a reasonable effort to protect confidential business information can vary depending upon the nature of the information. As I said before, other countries do protect trade secrets, but in different ways, and many U.S. trade secret owners simply decide not to take their trade secrets overseas. So where do we seek protection? And this is something that Richard will also emphasize. It is both a business decision and a legal decision. So when you are looking at where to seek protection, recalling that intellectual property is territorial, needs to be protected on a country-by-country basis, but we can't have it all, so we have to make some intelligent decisions about where we may decide to go. First, where you're selling your goods or services. Second, where you're thinking about selling your goods or services. Where you're manufacturing your products or parts of your products. Where counterfeiting and piracy are high. And where your competitors are. Now, you could add a few other factors to that list, but I think those are the basic factors. So when you're looking at the world, I just get out a big piece of paper and put this information on basically a spreadsheet on my kitchen table to decide where to go. I worked in private practice as a lawyer. I worked in corporate practice as a lawyer. And so while it sounds kind of, geez, is that what they do? They just write it down on a piece of paper on the kitchen table? That is a very, very good place to start. So the other question, in addition to where to seek protection, is when to seek protection. I'd already mentioned to you that patents are very time sensitive, and Richard will harp on that. But to me, it's very important to think internationally from the very beginning. Why? First of all, patent protection is time sensitive. Second, filing for trademark protection is not time sensitive per se, but it may be subject to squatting by others. You may be familiar with the concept of cyber squatting, or the squatting of one's trademarks by third parties as domain names. That happens with your trademarks as domain names. It happens with your trademarks as trademarks, and it happens also with your patents in some countries. So there are good eggs in this world and bad eggs in this world, and there are plenty of bad actors who are anxious to take advantage of your intellectual property. Where do they find it? They find it on the web. They find it at a trade show, unprotected at a trade show. They find it in trade publications. They find it in the Uspto, European, and other databases. And they don't hesitate to take advantage, particularly so in certain countries of the world. Copyright registration, at least in the United States, is time sensitive for some benefits, and that is also important to note, particularly if you are primarily a content creator. In other words, if you make videos or you develop software, that's important to have an understanding about copyright registration and when it should be done. And then lastly, trade secrets should be protected immediately, keeping it secret. So there are a number of resources, and they will be in your slides. But I'd also like to say that Richard and I are resources, and we are glad to take telephone calls and emails at any time where we'll have more time to explain issues to you. We cannot provide you with specific legal advice, but we can certainly provide you with a framework. We can provide you with a better sense of the issues, and we can provide you with a number of resources that will be helpful to you as you seek to export. I'm so glad you've come to this presentation today, because this is intellectual property in exporting is one of those unwashed, unloved topics. People have not paid attention to it, and businesses wonder how did they get hurt by this? You can even get hurt just staying in the United States by activities of bad actors overseas. But we can talk about that more when we come to talk time. Richard?
And there we go. I should be online. Hello, everyone. Yes, thank you, Susan. And yeah, I'm going to hit on a number of things that Susan has mentioned. First, let me introduce myself. Again, my name is Richard Cole. I am the Deputy Director of the International Patent Legal Administration. I've been at the USPTO since 1985. I have been in our International Legal Division since 1995. And hopefully I'm going to be gone from both in about 3 to 5 years. So that's me. Yeah, let's talk patents. Susan's kind of nailed down trademarks and copyrights and trade secrets. My area of expertise is patents and designs. First off, what is a patent? Let's hit that real quick. A patent is a property right. And as any other piece of property, it is something that you can sell. It's something that you can lease. It's something that you can keep for yourself. But the main thing about a patent that most people misunderstand is that a patent does not give you the right to make, sell, or use your own invention, surprisingly enough. What a patent gives you the right to do is to stop other people from making, selling, and using your invention. And I'll give you a real quick example that will kind of clarify why that is. Let's say that Susan invents a chair. She's the first person to ever design a thing that you sit on with a back and 4 legs. And she goes to the patent office and she gets a patent on it. She says, hey, look at this cool thing I've invented. She gives me one to use for a while. I put it on my front porch. I'm sitting there and I decide that if I put 2 little curved pieces of wood on the bottom, it'll rock back and forth and I can relax and it'll be a great thing. So I go down to the patent office and I say, hey, look, I've got a rocking chair. Nobody else has ever done a rocking chair. I want a patent. So the patent office gives me a patent on the rocking chair. Well, the problem is I can't make my rocking chair without first making Susan's chair. So as a result, I don't have the right to make a rocking chair unless I get Susan's permission to make her chair. So that's the idea. It doesn't give you the right to make your invention, to use your invention, but it gives you the right to stop other people from doing it. And the reason is because your invention may include parts of someone else's invention. So that's what a patent is. The patent is basically an exchange between you as the inventor and us as the US government. And what occurs in that exchange? Well, you tell us everything there is to know about your invention. And we then share that information with the public. And the idea is by sharing this information with the public, other people can take your invention and improve upon it. My rocking chair coming off of Susan's chair. The whole idea is that we want science to progress. We want innovation to further itself. So we take the information you give us and we share it with the world in hopes that things will get better. We will get better drugs. We will get better machines. We will get things that are better. But in exchange, we give you this right for a period of 20 years to stop other people from making it. And that way you get a return on your investment. You get to, again, license it, sell it, whatever you need to do to get some money into your pockets as a result of your invention. So it's an exchange. And that's what we do at the US Patent Office. And there are patent offices around the world, and we're going to get into the international aspects of filing patents. But virtually every country, for the most part, has a patent office or an intellectual property office. There's the Japan Patent Office, the Korean Patent Office. They're 2 of the big ones. China has filings everywhere, but there are also regional offices. Offices like the European Patent Office or the Eurasian Patent Offices. These are offices that have basically have a coalition of countries, and that if you get a patent in one of these regional offices, it's enforceable in all the countries that are party to whatever convention this this regional office has set up. So there are both national offices and regional offices. Now, there are also different types of patents. The three main types of patents, and Susan kind of touched on this earlier, are utility patents. And these are basically patents on an invention, a machine, a process, a method of doing something, anything that's manufactured and has a specific use. Or, as I said, not just the device, but also methods, a method of printing pictures, a function of a mobile application on your phone. These are utility patents. They are patents that have utility. A lot of people think, oh, I don't want a utility patent because that relates to power plants and that kind of stuff. That's not what the term utility means here. It's an object, an invention, a method, a process that has specific utility. It does something. Next, there are design patents, and that's basically it is a patent simply on the way something looks, the ornamental design. Examples of this, and you're like Susan said, you're going to get a slide packet when this is all over. In my slide packet, there are examples of the different type of design and utility and plant patents. But an example of a design is the Croc shoe. Croc shoes have a patent, or had one, it's since expired, but Croc shoes have a patent, and it's solely on the way it looks. There's nothing functional about the Croc design other than the way it looks. There are design patents on, as you can see, I'm a musician. There are design patents on the shapes of guitars. The famous Flying V guitar, there's a patent on it, or was, and it's simply on the shape of it. Sometimes this thing crosses over. And the example here is a Coke bottle. Coke originally got a design patent on the shape of the very distinctive shape of their soda bottle. Now, over the course of time, that bottle took on its own life, its own meaning, and people identified that shape of a bottle with Coke products. And so Coke now has a trademark on the shape of their bottle. So that's sometimes the design can cross over into a different area of intellectual property. The final type of patent are plant patents. Susan mentioned this. It's basically for a new variety of asexually reproduced plant that somebody has come up in a lab. And if you search for plant patents online, you will find some of the most beautiful flowers and trees and stuff you've ever seen that people have, come up with just amazing colors on. And so those are the three types of patents. They differ in another sense in how long the patent is enforceable for. As I said, with utility patents, the term is 20 years. For design patents, it's only 15 years. And for plant patents, they follow the utility model where they're also a 20-year period. Let me scroll down through my slides and skip over some of the ones here to keep going. Now, a very key thing that Susan mentioned, patents are territorial. And the only way you can get a patent in a given country or region is by applying for a patent in those countries or regions. If you get a US patent, it is only enforceable here in the US. It has no effect anywhere else in the world with regard to enforceability. Now, the other thing to note is there is no such thing as a worldwide patent. Like I say, there are individual country patents, there are regional patents, but there's no such thing as a worldwide patent. I'm involved in a number of committees and negotiations through the UN, where one of the goals is to eventually harmonize patent laws so that there is a worldwide patent or something similar to that. But I will tell you, my experience in these negotiations over the past 20 years has led me to believe that any such indication that a worldwide patent is about to happen is clearly a sign of the apocalypse and the world is about to end. There's very little momentum right now to come to some sort of an agreement on that. So you have to file for your patents in the areas you want to get patent protection in. And patent protection, as a result, is a very important part of your global business strategy. Now, as Susan mentioned, there are considerations regarding where you should patent. There are basically three types of considerations. There are business considerations, and Susan touched on this. Where are you marketing your invention? Where do you expect to market your invention? Manufacturing considerations. Where are you making it? Where do you think you might be making it? Where are your competitors making their products? Because you might want to go in and get a patent there so that they can't start making your product in the area where they're already making their own products. You want to consider the industry size and growth. You want to consider where competition is highest. And of course, as a small business, you need to consider costs, and there are different costs in different countries. Some it costs more to get a patent, some it costs less, and so you want to consider all that. Next are patent law considerations. There are different standards of patentability in different countries. There are some things, for instance, that are patentable here in the US that, because of various laws, are not patentable elsewhere. One that comes to mind immediately is methods of medical treatment. Here in the US, we allow you to get a patent on a method of medical treatment. In Europe, that's not the case. They feel that medical treatments should be available to all, and therefore you cannot get a patent. So there are patentable subject matter differences. There are also prior art differences. Certain things constitute what we call prior art, what's been done before. The idea behind a patent is you can only get a patent if what you have done is new, if it's never been done before. But in order to show whether or not something has done before, different countries have different definitions of what constitutes prior art. And one of the key things there, and I'm going to touch on this in a little more detail in a second, is, as Susan mentioned, the grace period. And that has to do with when a piece of prior art came into existence and whether or not it can be used against you. And then finally, the last type of consideration are enforcement considerations. Some countries are notoriously bad for enforcing patents that you get there. Some countries require that for something to be enforced, you as the patent owner must take action. So you need to monitor your competitors' products, what they're doing. And this is an area where, again, as a piece of property, licensing of your piece of property, renting it out to somebody in those countries may be very beneficial. Now, the grace period. This is very important. Here in the US, we have a grace period whereby if you disclose your invention, say you go to a trade show, or you have just people coming into your business and you demonstrate and show them okay, here's what we've got. You have, from the time you first disclose your invention publicly, you have 1 year in order to file your patent in the US. If you don't file within that year, and the US Patent Office is aware of that disclosure, we will reject your patent application based on that disclosure. Your own disclosure will be used as prior art against you. So we have a 1-year period. There are other countries that do not have grace periods. This is one of the areas of patent law that we've been trying for years to harmonize. There are some countries that have a shorter grace period. There are other countries that have none at all. Some have very restrictive grace periods. In other words, your disclosure cannot be used against you, but only under these certain conditions. You disclosed it at this sort of event, or you disclosed it in this sort of a way. So the grace period differs in different jurisdictions. And so the key thing to remember is, unless you are ready to file in other countries, you need to keep your disclosure to yourself. And we've been in any number of situations. Susan and I attend conferences and product fairs where inventors have come up with something and they've shown it at a trade show. And they know that they have a year to file in the US, but what they haven't realized is by showing it in the US, they've essentially shot themselves in the foot with regard to getting a patent, say in Europe or China, these countries that have very restrictive grace periods. On the slides, there will be a slide discussing the grace period, and on that slide is a link to a website through WIPO, and WIPO is the World Intellectual Property Organization. They're the branch of the United Nations that handles all of these intellectual property issues. And there's a link on the slide dealing with grace period to a page on the WIPO website that specifically discusses what countries have grace periods with international laws. So let's talk about foreign filings. We've talked about what you need, what a patent is here in the US, but let's talk about filing in other countries. There are basically two ways you can file for a patent internationally. The first is called a direct filing, or what we call a Paris Convention filing. The Paris Convention is a treaty that goes all the way back to 1883, dealing with the sharing of intellectual property and the patenting of inventions and the protection of trademarks and copyrights. It goes all the way back to 1883. The US signed on to it in 1911, but it is basically the granddaddy of patents, granddaddy of treaties dealing with patents. Under the Paris Convention, you file your application here in the United States, and then you have a 12-month period under which you can file applications in any of the 177 other countries that are party to the Paris Convention, and your US filing date will be recognized as a filing date in those countries. So what that does is you file here, within a year you file anywhere else, and any prior art that comes out within that 1-year period of time cannot be used against you in those other countries, because they will recognize your US filing date as the date you came up with the invention. You first applied for protection. So again, the reasons why you might want to file that way instead of the Patent Cooperation Treaty, and that's what I'm going to talk about next, is you may only have 2 or 3 countries that you want to file in, so you're ready to file right away in those countries. It may be, as a result, it may be cost effective because you only have to pay in those countries. but you need to be prepared to pay those filing costs early. The direct filing is also necessary for any countries that are not party to the PCT. As I said, there are 177 countries that are party to Paris. There are currently, where's that slide? I'm skipping down. I'm going to say there's 155 PCT countries, but I think that's about to change. Yes, 155 as of today. The most recent addition is Jamaica. They became a office on February 10th, so just a week or so ago. And me and a coworker of mine have been desperately trying to line up a visit to help them with their patent system. But there will be a 156th country joining in April. Iraq is going to become a party to the Patent Cooperation Treaty. So like I said, the Paris Convention serves 177. So there's about 20 countries or so that are part of Paris that aren't part of PCT. So in those countries, you need to file directly. Now, what is the PCT? The PCT is, and I'm keep looking over at my clock because I'm running out of time already. The PCT is a United Nations treaty. It was first signed in 1970. It became operational in 1978. And as I said, it's administered by the World Intellectual Property Organization. It is a filing treaty. It is not, again, you don't get a worldwide patent as a result of this. What it is a filing system whereby when you file a PCT application in one of the PCT member states, it is considered to be a filing as of that date in all 155 other PCT countries. You then have a period from that filing, if that was your first filing, of 30 months to file individual applications in the other countries. And I say if that's your first application, because if you can file, let's say, again, going back to the Paris route, you can file an application here in the US, and at 12 months, instead of filing that direct filing in the individual countries, you can file your PCT application, which then again is considered a filing in 155 countries. You have 30 months from your first filing, so you kind of get a year off to file individual applications. So again, it's a single application at that 0 or 12-month period, and we'll say 12 months because usually you file here in the US first, and then you file your application elsewhere. So at 12 months, you're going to file your PCT. You're going to file one application. You're going to file an application that meets one set of formality requirements, and it's going to go through a search and examination by an international searching and examining authority. In my slide set, you're going to see, as I said, there's 155 contracting states. There's a list of all those contracting states. And again, go to the WIPO website, www.wipo.int, but it's in the slides. Don't worry about it. There's a list of all the contracting parties to the PCT. Now, what are the benefits of using the PCT over the direct filing or Paris route? One, again, it simplifies the filing of applications. You have one application, you're done. It also allows you to postpone your costs of filing in all those other countries. As a result, it gives you a chance to figure out what countries do you really want to file in. And there are a lot of fees involved. It's not just the filing fees. There are translation fees. Your application here in the US is going to be in English. Other countries don't accept English, so you're going to have to translate into their languages. You're going to have to get attorneys in their country. Again, we have attorneys who practice here in the US, but their registration is only good here in the US, and we don't accept attorneys from outside the US practicing here. So there's a lot of costs involved, and it allows you to push those costs down, like I said, for a period of 30 months from your very first filing. Like I said, the application is also going to get a search and examination. So one of the international searching and examining authorities is going to look at your application, and they're going to give you a search report. They're going to go out, look for prior art. They're going to give you a search report and a written opinion that says, yes, we think what you have here might be patentable, or no, it's been done before, and here is the prior art that is usable against you. Again, it's not a patent, a grant of a patent, but it gives you an indication of whether or not other countries will grant that patent. I'm running out of time, so I'm going to skip down. Let me just say, with regard to help with the PCT, there are a couple of slides on here that deal with PCT resources, and the biggest resource I can give you is the PCT help desk. These are the people who work for me. They are the best in the office, bar none. You will not get better service from any other phone help desk in the USPTO than you will from my people. And if you don't get good service, I want to know about it. But they're the best. They're smart, they know what they're talking about, and they're experts in this subject matter. That number is, and again, it's in the slides, but it's 571-272-4300. I'm going to touch real quick on the Hague application process. The Hague is another international treaty, but unlike the PCT, which deals with utility patents and inventions, the Hague is limited to design patents. And it is similar to the PCT, it's a filing system for design applications. Again, it's a one application that constitutes a filing in, well, it can constitute a filing in 76 member states, but again, it's a single application as opposed to 76 separate applications. Under the Hague system, let's say you file your Hague application in the United States. We forward that application to WIPO. They then send it out to the other member countries. Under the Hague, the various national countries have 1 year to grant or refuse your application. Now, if they fail to issue a refusal within that 1 year period, it automatically becomes a grant of protection in that individual state. The Hague is, again, a procedural treaty, a filing treaty, so it does not determine the conditions for protection. It does not determine the start or duration of protection, and it does not determine the rights that result from protection. All those things are governed by the national law of each state. And the same is true for the PCT. Whether or not you get a national patent as a result of the PCT is dependent on the different national laws of every country. There are requirements that will allow you to use or not use the Hague. Again, I'm going to skip because we're down to 15 minutes. Those are all outlined in my slides, and there are some additional Hague resources that you can use. One thing I want to touch on real quick, and that's some helpful hints, some common mistakes in this whole thing. Again, as I said, due to the different grace period situations around the world, the biggest issue is confidentiality. Keep your device to yourself. Keep your invention to you, the people who work with you, who you have agreements with to keep things quiet. You need to keep it to yourself until you start filing your applications. That's the key thing. And again, remember what I said about you file in one country and then you have a year to file either a PCT or individual applications. Once you file that US application, then you can start telling people. because that US filing date protects you in those other countries. If you disclose it one day before your US filing date, you're then dead with regard to the countries that don't have grace periods, because you can only go back to that US filing date. You can't go back to that day before. So that's the biggest mistake, and the biggest thing to keep in mind is keep it to yourself. As Susan said, other thing to remember is that there are key dates and deadlines. In US practice, in foreign practice, and especially with the PCT, there are certain things that have to be done by a certain date in the timeline. And if you miss those deadlines, sometimes it can be fatal with regard to your application. There's no way you can recover from it if you miss some of those deadlines. So you have to know them. Now, that's a lot of things to have to know, because there's a lot of information in the PCT. There's a lot of requirements within the PCT. And that's why, for this last bit of advice, we recommend you secure the representation of a registered patent attorney. These guys know it. The one thing you want to make sure, though, is if you're thinking of filing internationally, you want to check and make sure that the attorney you're hiring has experience in foreign filings. The way you find an attorney is you can consult with your industry contacts. In other countries, you can check with the US Embassy in those countries. You can check with different inventor organizations. And finally, within the US, for attorneys that are registered in the US, we have a place on our website where you can find it. And again, that link is in the slide. A lot of other resources, there's just pages and slides and slides of resources, but I'm gonna let you dig through that on your own. As Susan said, we're always available for a call, or like I say, call my guys at the help desk. They're the best. So I guess that's it for me right now. Let's open it up for questions.
Thank you, Susan and Richard. That was awesome. So much information. I'm going to go ahead and share my slides. Give me 1 second. Okay, let's see.
To me, and not that Richard isn't endlessly interesting, but to me, the most interesting part of any presentation that we do together is when we get questions, because in the questions, we see what we didn't fully explain or what people just didn't understand. And we also get some new questions we've never had before that we incorporate into our presentation. So our work together is a culmination of many years of doing this together. Now, we were very subdued in a virtual meeting, but when we're live, we're quite Mutt and Jeff, I guess.
We bicker like Lucy and Ricky.
So we would love to have some questions. Please ask us some of your toughest questions. We're here.
Yes, let me. Right now we have no questions, and you guys touched on a lot of great advice. Earlier on in your presentation, I was going to ask what was the any advice you would offer to small or up and coming businesses. And I do know you guys mentioned, starting to think international from the beginning, always bringing up that, if you plan to export, you plan, and even if you don't plan, maybe just always start with that. So any advice on exporting or international for smaller businesses or enterprises?
Well, yes, I would like to speak to that, because I know that when Richard and I speak, I certainly know when I speak, it often sounds as if I'm only speaking of that which a large business would know or be able to do. And that is not my intention or our intention at all. We want everyone to have the same level of knowledge from which to pick and choose. It is true that a smaller business is not going to have the ability to have an in-house counsel, let alone an in-house intellectual property counsel. Might not even be able to easily hire an outside counsel. They'll have to think more carefully at every step. But it's very important, I think, to have the big picture and to know what you can do and what you cannot do. And I think if I were to say, what should I as a small business do? Well, the Stones, I think it was the Rolling Stones, sang about you can't always get what you want. But I think if you will do the following, you might get what you need. And I talked earlier about taking a large piece of brown paper, wrapping paper, putting it out on the kitchen table and making several columns. One column is those countries that Richard and I each talked about, where you're doing business, thinking about doing business, maybe manufacturing offshore. Many businesses do. We wish they'd keep it here at home, but many do offshore. Countries where counterfeiting and piracy are high. And then last, countries where your competitors are, or you happen to know that they're thinking about going. And then you have to figure out, well, what types of intellectual property do I have? And I said at the outset of my presentation that all of you have more copyrights and trade secrets than you have of others, I suspect. But you certainly have trademarks, and you certainly use patents you may or may not be inventing. But we do, of course, encourage everyone to always think about inventing. And even if you say, wait a minute, I'm not into plants and I'm not into the kinds of inventions that Richard talked about, but yes, ornamental design on a functional article, I never knew that could be protected. I have quite a few of those products or ideas. So then I put down all my intellectual property. And it can take a while to figure out exactly what you have. And then in my third column, I have to figure out what's possible for me to protect in each country. And there I have to see, how do they protect, depending upon my assets, how do they protect patents? How do they protect trade secrets? How do they protect copyrights? How do they protect trademarks? I also have to, harsh reality, look at the approximate costs. But I also need to look at the risks of not taking those steps, because the reality is that, as we said, intellectual property is territorial. You need to protect it on a country by country basis. If you don't have a trademark registration in that country, that's almost all countries, or you don't have a patent in that country, you have no way to enforce, which means that people can then chuck their goods out to other countries, and including sending back into the United States, which is why I said that even if you're just in the United States and you're thinking, whoa, exporting's not for me, and this presentation convinced me, you're still subject to attack because of the influx of infringing, counterfeit, pirated, patent infringing products coming into the United States, which very well will be the market of everybody on this call. So I would say, what is your big picture?
And
Yes. Oh, go ahead, Richard.
I
Sorry.
just jump in. One of the things we talked about in, prioritizing what and where and why and all that kind of stuff. I say this almost every time Susan and I present. Even though I'm the patents guy, in many ways, I feel that your trademark, your company name, that is the thing you should look at first in protecting. Because you wind up in a situation where a company in another country where you don't have trademark protection starts making an inferior device to yours. And it may be a device that's completely different from yours. Therefore, it wouldn't infringe on something you might have a patent on. But they're making a shoddy device and they're putting your name on it. And then they're shipping it here or elsewhere in the world with your name on it, and somebody's going to get that and they're going to, well, this company makes crap, excuse me. I'm not buying anything from this company again. So in many ways, while again I'm the patent guy and patents are very important, if I was running a business, my first line of protection would be to protect my company's name.
And while we're at it, and thank you for that vote of confidence. I've never really known you felt that way about me.
I say that every time we meet, you know that.
But we also want to take a look at domain names. And I think probably most everybody on this call is used to thinking about .com because that is the most popular top-level domain. But when you're looking at other countries, each country has its own country code top level domain, but getting your domain name registered with not the trademark office, but with a domain name registrar in another country can be challenging because the requirements on a country by country basis are really wildly divergent. But that too is something that you want to think about. And I always say to people, think about these things earlier rather than later. Perhaps the most heartbreaking statement I ever heard, and I've remembered it all these years. I was in Minnesota, and we had done a series of presentations for U.S. Export Assistance Center there. It was really a very lovely, lovely time. That's one of the great privileges and pleasures of working on behalf of the American people. But I remember the director there, whose name I've long since forgotten, but he said, what you're saying about thinking about these things earlier rather than later is so true. He said, I had a group of 5 men who came to me, and they had been wildly successful with their patented invention. They had gotten a patent in the United States. They knew, of course, they had to have a patent. What they were sitting on was gold. But they never believed that they would have any success outside the United States. So they never took steps to obtain an invention in Europe, which now wanted their product in a very, very, very big way. So then what you're stuck doing is you make a refinement, a patentable refinement to your product and get a patent on that. But that is not the same as having that patent. So the fellow said, that's going forward, I'm going to stress to our clients that come into the U.S. Export Assistance Center, think about the big picture from the get-go. Think about what you'd really like to see and what you'd really like to want, and then what you really want, and then figure out how to get there.
Thank you, Susan. That was amazing. Both of you had great answers to everything. I did want to mention the stop fakes. I know we had a conversation about that earlier and how important that is to Native American enterprises and even businesses, small businesses that are protecting their intellectual property. Would you like to talk a little bit about that, Susan?
Sure, I would like to. Stop Fakes is an initiative that was rolled out in the fall of 2005. Gosh, that is a long time ago now. I've been at the agency for over 18 years now, so I remember that. And the idea behind Stop Fakes, it's bipartisan, so it's not a political thing. Bipartisan effort to level the playing field for businesses, particularly the smaller business across the globe. And we don't get nearly as many calls or emails as we used to. I still get calls and emails, as does Richard, which we call Stop Fakes, but people don't necessarily call through on the Stop hotline anymore. But I still do remember my very first call. And this is a very good example of how you can get hit just sitting in the United States. And so early on, we had a lot of calls about China. As a matter of fact, throughout the duration, we get a lot of calls about China, but by no means are those the only calls. People call about how to protect in the US, and they also talk about how to protect going overseas. And the caller said that he had a small company up in New England, and he was calling the government for help. Federal government, here to help you. And he wanted to know, he said that he had just discovered that he was being ripped off by a company in China. And so I remember asking him, have you obtained your patents in China? Have you obtained your trademarks in China? And I heard silence at the other end of the line, and I just knew from the frostiness with which he answered me that he thought I was brain dead and had not bothered to listen carefully to what he had just said to me. And then I asked him about, had he obtained patents in the US, had he registered his trademarks in the US? And I don't generally care overly much about that answer, but it tells me something about the importance of intellectual property and the importance of the strategy of having an IP portfolio. And I don't remember what his answer was, but then like any good attorney, I always ask that one question too many. And I asked him about getting was he going to get his intellectual property in China? And he said that he had absolutely no intention of doing so. And at this rate, his company was going to be gone and he would never seek to get intellectual property in China. And so I always ask people when they hear that story, what is the answer to his question? What were his options? And everybody pretty much says the same thing. If you're talking about a patent, no option. If you're talking about a trademark, maybe, but that's only if the trademark is well known in China, which means well known to the relevant public in China. And while you might think Coke and Pepsi would be well known in China, they've had their challenges. So those of us who are much, much, much smaller aren't going to be at that same level. So Stop Fakes is an education initiative. And I guess that's kind of how we got started in all of this. It's how Richard and I ended up doing trade shows, because when we first started out, we did trade shows. And I would just like to say that, of course, we're still teleworking, we're still in pandemic mode, but once all of this lifts, I have been at Res for any number of years. Love Res, would love to get Richard to Res. Oh, what a nice time we have. And always delighted to talk with anybody that's a Native American, Alaska Native, or Native Hawaiian business. The door is open, the phone is on.
Thank you, Susan, and thank you, Richard, for presenting today, and thank you for plugging in Res. We are having an export track this year, and we would love to have you guys on as well. We can discuss that further in detail later. Again, let me advance my slides about our operator. So the National Center has been committed to economic development for Native American and Alaska Native communities for over 50 years. The National Center provides business training, procurement, and technical assistance, and now exporting needs. You can learn more at our website, www.ncaied.org. And please register for Res 2022. We will be at the Caesars Palace, May 23rd to 26th. And there's a registration link for that. All slides will be provided after the webinar. Thank you guys for joining us and tuning in. I'm sorry we're a little over 12, but that's okay. We had a great discussion. Again, thank you for joining us. Here's my email. Please feel free to contact me if you want to export and if you want to get connected to Susan or Richard. Thank you guys so much for joining. Have a great day.
Thanks, Shelby.
Thank you.